Hello, this is Professor Keith Ross from the John Jay College of Criminal Justice. This is a series of lectures for my criminal justice classes. Um, this lesson that I'm going to do was not really in the book, or I don't really like the way it was explained, so I'm going to use this PowerPoint. I think it better illustrates how this stuff works. So I'm going to get right into it. What we're going to be talking about today, the name of this chapter is Policing Legally Investigative Encounters with the Public. Really, I'm going to be talking about two cases. The first case I'm going to be talking about is Terry versus Ohio, and then a New York State Court of Appeals case, People versus Debour. I'm really going to concentrate on the Debour case because this is where a lot of misinformation and a lot of misquoting sort of takes place. So I want to make sure that you understand the concepts of what a forcible stop is, what that actually means, and really the main difference between two terms that are almost used interchangeably, and they really should not be because they're very different things. The two terms that I'm talking about are reasonable suspicion and probable cause. So I'm just going to get right to it. Everything that we're going to be talking about today, when we're talking about forcible stops, that is considered to be a seizure. And if it is a seizure, well, it's under the auspices of the United States Constitution, specifically the Fourth Amendment. What is the Fourth Amendment? Well, the Fourth Amendment protects citizens against unreasonable. Do me a favor, underline that word, unreasonable. The word is not illegal, it is unreasonable governmental searches and seizures. This could either be searching or seizing a residence or searching or seizing a person. Now, this term unreasonable, well, what does that mean? Well, you know what? That has to be taken on a case by case basis. So this is not really a black and white term. Well, this was reasonable, that was not unreasonable, although there are times when we can intuit what might be reasonable and what might not be reasonable. But what's going to happen is, and I think I've talked about this before, is that the reasonable person test has to be employed here. That given the set of facts and circumstances at the time that the police officer conducted either this search and or seizure, could be an arrest, that is a type of seizure, was it reasonable? Would a reasonable person, looking at all the facts and circumstances at the time of this incident and knowing everything that the police officer knew at the time of this incident, not hindsight 2020, would it be reasonable? Okay, constitutional considerations. Now, this is a concept that at least one of my classes, my policing class, they did a case brief on United States versus Leon, and that talked about good faith searches, and it also talked about this idea of the exclusionary rule, or fruits of the poisonous tree. You can use those terms interchangeably because they mean basically the same thing. The exclusionary rule is pretty simple. What the exclusionary rule means is that evidence that is obtained illegally via a bad search or a bad seizure will be excluded from evidence, will be considered to be inadmissible from evidence. If I'm a police officer and I'm in uniform and I just throw someone up against the wall and I reach into their pockets and I pull out a gun and I can't articulate why I conducted that stop, that gun will be excluded because the stop wasn't a good stop and the search subsequent to that stop wasn't a good stop. As a matter of fact, you're really not even supposed to search at stops without some further investigation. Now, this idea of fruits of the poisonous tree is the same thing as the exclusionary rule. And basically, what we're talking about here is if I have a healthy tree, what kind of fruit do I expect that healthy tree to bear? The answer to that would be healthy fruit. So, the way this works is if I have probable cause to effect an arrest, this is a quote unquote good arrest or a healthy arrest, meaning that this arrest, based on probable cause, and let's throw in good faith there, is my healthy tree. So now I conduct a search, and this is going to be called a search incidental to a lawful arrest. And in a later chapter, we'll discuss that, these court recognized exceptions to the search warrant rule. If I conduct a search head to toe, and let's say I recover a gun, well, since the arrest was good, meaning I have a healthy tree, the search subsequent or incidental to that arrest will also be considered to be good, and any evidence that I obtain via that good search from that good arrest will be considered to be admissible. It will be included in the trial. Now, let's just say I get a description of a perpetrator that committed a robbery 1 minute in the past, and the only thing that I have is that it was a male white. Now, given wherever we are, more likely than not, there's going to be at least anywhere from 5 to 10 people that fit that immediate description. So I pick the first one I see, and I say, "You're under arrest." Well, right now, here's the question. Would a reasonable person think that this is a good arrest? Well, the answer to that question hopefully is going to be no, because what was the description? A male white. Is that a good enough description? Is that a detailed description? I'm going to say no to that. So now let's say I place this person under arrest and I search them incidental to this arrest and I recover a gun. Well, now let's talk about fruits of the poisonous tree. If I have a unhealthy or a poisonous tree, what kind of fruit do I expect that poisonous tree to bear? I expect it to bear poisonous fruit. So if I have a bad arrest, an arrest not based on probable cause, an arrest not based on good faith, that search subsequent to this arrest, whatever evidence that I find, to at this point, the gun, will be excluded from the trial, because since the arrest was not based on probable cause, this was a bad arrest or a poisoned arrest. And any fruits from this arrest will also be considered to be poison and therefore will not be admissible in court. Okay, I'm on slide number 5, Terry versus Ohio. This is a landmark United States Supreme Court case. And basically, what it talks about, I would actually like you guys to just maybe read it, because most people have heard Terry versus Ohio and what Terry stops are. More often than not, usually what people say is that Terry versus Ohio is where stop, question, and frisk comes from. Not really the case. Stop, question, and frisk is never mentioned in Terry, nor is the term reasonable suspicion ever named in Terry. Basically, what happened was there was a detective that observed two individuals, quote unquote, casing a store. And with his 33 years of experience, he was expecting a burglary. What Terry talks about is police having the right to conduct limited searches with less than probable cause. Now, when we talk about limited searches, really what we're talking about are pat downs. And we're talking about less than probable cause. And this is where that term reasonable suspicion is going to start coming from. But what Terry talks about is limited searches with less than probable cause. Terry stop is an encounter where with a police officer where a reasonable person would not feel free to walk away. If we have a person who does not feel free to walk away, that is considered to be custody. So whenever you hear the term custody, think not free to walk away. It is considered a seizure under the Fourth Amendment, and it requires this term of reasonable suspicion. I'm going to define it in a bit. Reasonable suspicion is individualized suspicion based on specific facts. It is less than probable cause. Officers may frisk for weapons only in New York State if they reasonably suspect that the person stopped is armed and dangerous. So in New York State, and I'll say this again, police officers are not allowed to frisk for contraband, fruits of the crime, except for weapons and drugs. Now, the meat and potatoes of this lesson is going to be slide number 6. People versus Debour, the New York State Court of Appeals created a four-tier analysis that dictates the limits on the levels of permissible police intrusion. For my criminal investigation class, we talked a little bit about this in chapter 2, and I told you that there was a mistake to cross out what that level 2 was in that textbook. This is what I want you to follow. This is factually correct. You can feel free to look it up, Google away if you like. So there are four levels of police knowledge or police intrusion into a citizen's day-to-day affairs. Level 1, which is a request for information. Level 2, which is a common law right of inquiry. Level 3, which is a Terry stop. And Level 4, which is an arrest. I'm assuming my students have printed out this PowerPoint. If you have printed out this PowerPoint, there are some things I'm going to want you to write on slide number 6. What I want you to do is level 1 and level 2, request for information and common law right of inquiry, bracket those two together and put next to them, those are considered to be non-custodial stops, meaning that the person is free to leave at any point during this quote unquote stop. It is not considered to be a forcible stop. Level 3, Terry stops, and level 4, arrest. Bracket those two together and put next to them custodial stops, meaning that the person is not free to leave. They are in custody. Okay, I'm on slide number 7. May a police officer approach a citizen to request information without having any indication of criminal activity? And the answer to this question is absolutely yes. What happens if a police officer is investigating a missing 13-year-old? What do you think that police officer is probably going to do? Well, they're probably going to ask people questions. They're probably going to ask people outside, hey, have you seen this child? If I, as a police officer, ask this question, have you seen this child? Am I inferring any criminality on your part? The reasonable person would say no, that what the police officer is doing is requesting information from the public. Why? To solve this case. In this case, to find the missing child. So, level 1, request for information. This is the lowest level of police knowledge or police intrusion. Yes, provided that the approach is based on an objective, credible reason. Was there an objective, credible reason for the police officer to ask, have you seen this missing child? The answer to that is yes, to hopefully find the missing child and hopefully find that child alive. Not based on curiosity, bias, or intent to harass. If I'm looking for a missing child, I'm just asking information. There's no semblance of criminality here. So there's no reason, there's no intent to have some sort of a bias. May only ask non-accusatory questions. Here's an example. Let's say I'm looking for this missing child. So I approach a person and I say, excuse me, sir, have you seen this missing child? No, I haven't. Hey, do you sell drugs? Now, is there any sort of nexus between that first question, which was what? Have you seen this missing child? To the second question, do you sell drugs? The second question is an accusatory question because if you answer that and you answer it one way, you are answering it in a way that is against your legal or penal interest. So, a court would ask, officer, what were the two questions you asked? First question I asked was, have you seen this missing child? What did the person respond? They said no. What was the second question you asked? Do you sell drugs? Any good defense attorney, and maybe even a judge, is going to ask, well, why? Where did you make this jump from investigating a missing child to investigating the person that you asked about the missing child into some sort of drug investigation? Person must feel free to leave, and a police officer may not ask to search. Here's another example. I'm a police officer. I approach a person. Excuse me, have you seen this missing child? And let's say the person has a knapsack on them. Excuse me, have you seen this missing child? No, I have not. Hey, do you mind if I search your bag? Well, now again, this sounds weird. And a good defense attorney, what they're going to do is they're going to say, officer, what were the two questions you asked my client? Well, the first question that I asked was, have you seen this missing child? Do you remember what my client responded? He responded, no. What was the second question that you asked? Can I search the bag? Can I search the knapsack? And a good thinking defense attorney is not going to yell, is not going to scream, but what they're going to do is they're going to say, Officer, what was your reason in asking to search that bag? Were you expecting to find the missing child in that bag? Now, maybe some of you are sort of snickering about that, but that's a legitimate question. Why were you asking to look into the bag? If you're investigating a missing child and there's no criminality, we're not sort of inferring that the person that was stopped at this request for information encounter was a kidnapper. That would be something completely different. Okay, level 2, common law right of inquiry. Underline these two words: founded suspicion. Founded suspicion that criminal activity is afoot, based on observable conduct or reliable hearsay information. This is more than just a hunch. This is just more than looking at a person and saying, that person is up to no good. I'm going to go talk to them. You need to be able to specify and articulate where you had this founded suspicion. Here's an example. A lot of my John Jay students know the area. Let's say we're talking about 58th Street between 10th and 11th Avenue. There's a whole, or prior to the pandemic, there was usually a lot of cars parked there. Let's say I'm a police officer, I'm working, it's about, let's say 10 and 11 o'clock in the morning. I watch a person walking down the street slowly. Walking down the street slowly, not a crime yet. Stops at the first car, bends down, peers into that car, looks around, stands back up, goes to the second car, does the same thing, goes to the third car, same thing, fourth car, same thing, fifth car, same thing. Right now, thinking about this and maybe knowing what you all know, would anyone here think that there's something odd going on here, more than just a hunch that you've observed some sort of unexplained conduct that could possibly lead to criminality? Now, I would say that the answer to this is yes. Does this mean I'm going to effect an arrest? Absolutely not. I'm not anywhere near probable cause. I'm not even anywhere near like this idea of reasonable suspicion where I could conduct a forcible stop. But could I talk to this person and ask some questions? Maybe ask a legitimate explanation for their conduct. So at this level 2 encounter, so I go up to this person and I say, hey, buddy, what are you doing? Are you looking to steal cars? Now, the person cannot feel that this is a forcible stop, that they are in custody. And I don't have my hand on my gun or anything like that. I just go up to him and say, hey, buddy, how's everything going? Are you looking to steal cars today? The reasonable person would probably say that this person is not in custody, nor should they have perceived that they were in custody. But did I ask a pointed accusatory question? I absolutely did. Are you looking to steal cars today? Because if the person answers yes, again, that is against their legal or penal interest. And if they said yes, that might be enough to actually effect an arrest. Could I continue to observe the subject without approaching? Absolutely. What that is, that's called a surveillance. Surveillances are basically an observation. I don't need to articulate why I'm conducting a surveillance. I don't have to articulate why I'm conducting an observation. That's one of the things that good police officers do on a day-to-day basis. They conduct observations, they observe their surroundings. May request consent to search, but the consent must be voluntary. Now, getting back to my weird example of the person that's peering into cars. So I go up to him and I say, listen, are you looking to steal cars? And he says, no, I just like dashboards. Is that a legitimate answer? I guess so. Okay, have a nice day. Did I ask a specific accusatory question? Did I get an answer for that accusatory question? Did I find, at least at this point, that the answer to that accusatory question was good enough? Let's just say yes. Could I continue to observe this person? Absolutely. Level one versus level two. Level one encounters these request for information encounters. The officer has an objective reason to ask for information, an objective, credible reason. Think about the missing child. Level two, the officer has information that indicates possible criminal activity, more than a hunch that the officer has a founded suspicion that criminality is afoot. Can we conduct forcible stops? Not as of yet. Level one and level two, I'm on slide number 12, cannot use or threaten any level of force. Because if I were to threaten to use force, whatever that force is, it could be, listen, if you don't answer my questions, I'm going to arrest you. Could be taking out, a retractable baton, pepper spray, anything like that. Since that's force, now that person would probably feel that they're in custody, and that would be a higher level of knowledge or suspicion. Individuals, again, must feel free to leave. Refusing to answer questions or walking away does not raise the level of suspicion. You can always refuse to answer questions because people have a Fifth Amendment right to not self incriminate. Here's the odd thing, and I'm not, it's not anything that I'm going to test on, but there are some gray areas in the law. Events and observations at level one or level two can elevate the encounter to level three. And again, we have to employ this reasonable person standard. If I had a level two encounter like the one I described, and this person, I go up to him and I say, hey, buddy, are you looking to steal cars? And he starts running away. Well, now, does anyone here think that my suspicion level should maybe go up? Well, a reasonable person would probably deduce that, well, the officer had founded suspicion, and upon asking this accusatory question, the person ran away. So maybe this person is suspicious. Maybe this person was looking to break into cars to either steal a car or steal contents contained within. Okay, I am at slide number 13. Level 3, Terry stops. These are what are known, at least in New York, stop, question, and frisk. The reason why they're called stop, question, and frisk in New York is because the name of the paperwork for the NYPD used to be called, and still is called, a stop, question, and frisk report. But in your books, they correctly call these Terry stops. And Terry stops are based on reasonable suspicion, the quantum of knowledge necessary for a reasonable person to reasonably suspect a crime has been, is being, or is about to be committed. That comes straight from the New York State penal law. So, what is a forcible stop? Whenever a reasonable person would not feel free to disregard the police officer and walk away. If a person feels that they are not free to leave, that person is in custody, and now we are at the level of a custodial stop. Physical force or the threat of force is not necessary to constitute a stop. It is the person who's being stopped and their perception of the stop. If commands or questions would lead a reasonable person to conclude she or he is not free to leave, this is considered to be a forcible stop. Now, this is generally for NYPD police officers, this PowerPoint. When can you stop the person? In the 5 boroughs on or off duty. So the 5 boroughs for the NYPD is considered to be their geographical area of employment. So reasonable suspicion. Let's say I'm a police officer, I'm in uniform, and no reason to doubt that I am impersonating. I watch a person walking, because what do police officers do? They observe. So I'm conducting a surveillance. I'm just observing my surroundings. I see a person walking down the street. Let's say he has a shirt like this on and it's out, it's not tucked in. Person looks at me, starts shifting their eyes, and I notice a bulge in their waistband. Now, the bulge in their waistband, in my training and experience, signifies to me that this person might possibly be armed and dangerous. So now, as a police officer, what can I do? Well, now I can conduct a Terry stop, a forcible stop. So I'm like, come over here. Let's say the person complies. I put the person up against the wall and I ask them, what's that in your waistband? Do they have to answer me? They absolutely do not have to answer me. Why? Because the Fifth Amendment says that they do not have to answer. They never have to say anything that might be against their legal or penal interests, anything that might self-incriminate. But I, as a police officer, can I conduct a limited search? Yes, I can. And this is called a frisk or a pat down. Not going inside a pocket, that's a search. A pat down is basically rubbing your hands on the outermost layer of clothing or garment that the person has on. Now, in a case like this, I can only pat down the area where I reasonably suspect that person to be armed and dangerous. So now I'm feeling, and I feel what to me feels like the butt of a handgun. And I say, what is this? Let's say the person never says anything to me. But I, as a police officer with training and experience, and even a reasonable person, would reasonably suspect that this person is armed and dangerous. So now, what I can do is, since I can articulate what I felt, I can actually now further investigate, lift up that shirt, and pull out what I reasonably suspect to be a firearm. Now, if it is a firearm and the person is not a licensed firearms owner in the state of New York, well, now I can effect an arrest. Question though, and you can look this up on Amazon. Let's say, same set of circumstances, put this person up against the wall. I feel what to me feels like a butt of a firearm. Ask what it is, person says no. So I feel, I do my pat down, I do my frisk, I feel the butt of a gun. I pull it out and I find out that this is a cell phone case cover shaped in a gun. Here's my question. Was the stop good or bad? Well, most reasonable people would argue, and most lawyers and judges would agree, that at the time of the stop, what did the police officer reasonably suspect? The police officer reasonably suspected that the person had a firearm. Did he or she, the police officer, know that it was a cell phone case? They did not. So the stop was good. The frisk was good. Even this limited search pulling out the firearm was going to be good because that police officer conducted it in good faith. That was tough to say. The reasonable amount of force may be used to stop or detain. So if a person was, let's say, at that founded suspicion common law right of inquiry encounter running away, and I grab them and I throw them up against the wall, that would probably be considered to be reasonable. If I shot them, that would considered to be excessive or unreasonable. The type and amount of force must be objectively reasonable. I don't really care about the handcuffing thing. It's not anything that I'm going to test on. Slide number 15. A stop is permissible only when individualized reasonable suspicion, again, the quantum of knowledge necessary for a reasonable person to reasonably suspect a crime has been, is being, or is about to be committed. And notice a couple of things that I say. I said a crime. So what is crimes? If you remember Law and Justice, crimes are defined as misdemeanors and felonies. In the New York State Penal Law, they even go a little bit further, that reasonable suspicion or Terry stops can only be conducted with penal law, New York State penal law misdemeanors and any felonies. So a stop is permissible only when individualized reasonable suspicion exists when the person stopped has committed, is committing, or is about to commit any felony or penal law misdemeanor. The officers must be able to articulate specific facts that justify the stop. They're going to have to justify what they did, how they did it, and most importantly, why they did it. What is reasonable suspicion? I've already defined it twice. Here's another way of saying it. When the information an officer has is of such weight and persuasiveness that based on the officer's judgment and experience, it is reasonable to suspect that criminal activity is afoot. Must be individualized, particularized, objective, and supported by specific facts. So a police officer can't say, well, he just darted his eyes. Police officers need to be able to articulate the full set of circumstances as to why they conducted a forcible stop and sort of deprived a person of their Fourth Amendment liberties. Hunches, gut feelings, not sufficient. Factors that may be relevant to reasonable suspicion, information from an identified informant. And basically, when we're talking about identified informants, we're looking for two things. One, that they're giving us credible information, meaning that they're giving us good information and that they are reliable with that information, that the information that they've provided us in the past has been good. Or maybe a victim statement or an independent witness statement, matching a specific description, not just race, age, and gender. You can't say I'm looking for a male white 17 years old. I'm going to need to know things about this 17-year-old male white. Well, how tall are they? What's their complexion? What was their hair color? What do they weigh? What were they last wearing? Is there anything that makes them stand out in a crowd? Do they have, let's say, a lazy eye? Do they have tattoos? Anything with the teeth, scars, things of that nature? Carrying objects in plain view used in the commission of a crime, things like Slim Jims or hangers to open up cars, pry bars, things of that nature. Actions indicative of casing victims or locations. If you're casing a victim, more likely than not, you're probably going to commit a robbery. Location, more likely than not, a burglary. Additional factors that may be relevant to reasonable suspicion, actions indicative of acting as a lookout, engaging in drug transactions, concealing or possessing a weapon, or proximity to a recent crime scene. Excuse me. The factors listed are only factors that may be relevant. You're still going to need more information in determining reasonable suspicion. Any one factor in isolation may not lead to reasonable suspicion. So it is the totality of the circumstances. It's not just one fact, but maybe if I have 4 or 5 different facts and I put that data together, that might give me enough to articulate my reasonable suspicion to conduct a forcible stop. Information from anonymous sources. Reasonable suspicion cannot be based solely on anonymous sources. The only exception that I'm going to give to you is like exigent circumstances like bomb threats or kidnappings. Don't worry too much about that. Skipping to slide number 21, may detain suspect for a reasonable amount of time. Now, again, this is going to be a reasonable person. I, as a police officer, think 20 to 30 minutes can be a reasonable amount of time. I've heard other police officers articulate an hour, other police officers articulate 2 hours. It really just depends on your training, your experience, and how you articulate it to a judge and or a lawyer. An address and explanation of conduct, but suspect is not required to answer, and a refusal does not give a reason to arrest the individual. So, invoking your Fifth Amendment right to not self-incriminate does not bring level 3 or reasonable suspicion or Terry stop encounters to that level 4 of arrest. May ask pointed accusatory questions related to the reason for the stop, as well as pedigree information. So I can ask questions about the reason why I'm stopping that person. Hey, what's in your waistband? Is that a gun? I can actually say that, and that is an okay question. But if I ask, hey, what were you going to do with that gun? Were you going to go rob old ladies? Well, now that might be considered to be a bad question, because why? What am I conducting? I'm conducting a Terry stop. Terry stops are considered to be forcible. Therefore, that person is in custody. Now, I can ask a question about a present conduct. What's that in your waistband? Is that a gun? But if I ask that second question, what are you going to do with that gun? Are you going to go rob old ladies? Well, what am I doing? Well, I'm asking about questions about criminality, and that's considered to be an interrogation. Custody plus interrogation invokes what? Miranda warnings. But to ask, hey, what's in that waistband? Is that a gun? I don't have to read Miranda first before I ask that question. Again, people may refuse to answer. Refusal to answer, again, not a reason to arrest. Stop and frisk are two separate things. So police officers can always conduct forcible stops if they have reasonable suspicion. They cannot always frisk if they have reasonable suspicion. Police officers are only permitted to conduct a frisk when there is independent reasonable suspicion that the person is armed and dangerous. It is limited to a pat down, not a search. On the outside of the suspect for dangerous weapons, it cannot be used to search for evidence of a crime, such as drugs. An officer cannot go inside of pockets or clothing during the frisk unless they reasonably suspect that person is armed and dangerous. Uh, 25, armed and dangerous. Officer observes a weapon. Officer has knowledge the suspect may have a weapon. Suspect states that he or she has a weapon, or a witness or victim states that the suspect has a weapon, or reasonable suspicion of a violent crime. Violent crimes, things like obviously murder, manslaughter, sexual assault, robberies, and burglaries. Burglaries are considered to be violent crimes. Frisks of a portable container, I don't really care too much about that. I'm going to skip to 27. A search is the placing of hands inside a pocket or other interior part of clothing or possessions. It is only permitted to remove an object felt during the frisk that the officer reasonably suspects to be a weapon. I would star that. That is really what Terry stops are for, to reasonably stop a person, and if as a police officer you reasonably suspect they have a weapon, you can pat down. If you feel what it feels to be a butt of a handgun, you can lift the shirt up and remove that lifting the shirt up and removing the firearm is considered to be a search, and it would consider to be a good faith search. It would not be excluded. It is not considered to be fruits of the poisonous tree because the actual stop was good. And now, funny enough, since I pulled out the firearm, and if the firearm, let's say, is defaced or the person doesn't have a license to have that firearm, well, now I can effect an arrest. And the arrest will be based on probable cause, based on that frisk. I know it gets a little confusing. The purpose of the search is for officer safety and not to discover other evidence for the crime. Uh, 28, level 4 an arrest. An arrest requires probable cause. What is the definition of probable cause? Probable cause is basically that an offense has been committed and the person who is about to be arrested probably committed the offense. That a reasonable person would say that person probably committed the offense. If you look at legal documents, you'll never ever see the term probable cause. What you will see are one of two other terms, and they mean exactly the same thing: reasonable cause to believe or reasonable grounds to believe. So probable cause equals reasonable cause to believe equals reasonable grounds to believe. Don't get that confused with reasonable suspicion, and don't get that confused with founded suspicion. And I think that is going to be it for me. I wish you guys all a great day, and I will see you again in the next lecture. Take care. Bye.